average is not invited. Not if you're holding your company off-site in Las Vegas. We aren't on friendly terms with the bare minimum, and unenthusiastic is uninvited. Las Vegas's creative energy and world-class hospitality want to bring your company off-site to crazy new heights. That's why fear-based leadership is afraid of Vegas. And boring? Won't be there, but it will be watching the meeting recordings later. Plan for the extraordinary at vegasmeansbusiness.com.
Welcome to the Monopoly Report. The Monopoly Report is dedicated to chronicling and analyzing the impact of antitrust and other regulations on the global advertising economy. If you are new to the Monopoly Report, you can subscribe to our weekly newsletter at monopoly.marketecture.tv, and you can check out all the Monopoly Report podcasts at monopolyreportpod.com. I'm Alan Chappell. This week, my guest is Peter Craddock, a partner in data protection at the law firm Keller and Heckman. I'm excited to get Peter's thoughts on the concept of consent in a digital ad setting. My listeners on the business side may not know of Peter, but Peter was instrumental in building out the IAB EU TCF over the years and was one of the key lawyers for the IAB in its defense of the TCF in front of the EU Court of Justice over the years. I imagine Peter and I are going to go pretty deep on consent, on the definition of personal data, and have a really interesting and back and forth. I can't wait. Let's have at it. Hey, Peter, thanks for coming on the pod. How are you?
I'm doing well. Thanks, Alan. Thanks for having me.
Oh, it's my pleasure. It's great to meet you. So let's walk through the history of consent in the ads marketplace in Europe over the years. And so what I'm going to try to do is yada through about 20 years of history and see if we can come up with something that's sort of coherent. But there was a time when it wasn't clear that an IP address was personal data, and the e-privacy directive required a consent for cookies, kind of. You know, it was sort of maybe an implied consent. And so what was that? Because you've been in this space a while. What was that from your perspective, until 8 years ago? Kind of walk us through the marketplace back then.
Well, the thing is that until we had the Breyer judgment of 2016, there was a lot of uncertainty about what is an IP address. Is it personal data? Can it be personal data? Is it always personal data? And if you think about it, the questions that we were asking regarding IP addresses, we were also asking regarding cookies. Because if you think about the values that are stored in the context of cookies, they have similar characteristics. It's not necessarily linked to an identity. It might be linked to a device rather than a person. And so there were similar considerations. And so a lot of the time, organizations were just taking the position, well, probably not. It's probably not personal data. We're not using it as personal data, so it should be more or less safe. And we should be able then to avoid the rules of the Data Protection Directive at the time as implemented in national law. And the rules were indeed a bit more flexible in that respect. There was this idea that consent might not be as strictly interpreted as it is nowadays. And so you could get away with more simply also because there was less enforcement. So then we had the Breyer judgment. And so that was a really interesting one. It's a kind of foundational bit of case law, because in there, the Court of Justice of the European Union basically said information like an IP address can be personal data if someone in that context, it was basically the website administrator, the website operator, if that someone has means at its disposal, lawful means at its disposal, to basically get additional information to tie the IP address to a natural person. And so there was a very specific use case, and that was in the context of basically cybercrime, that it would be possible to get the public authorities involved and to figure out who was behind an IP address. And so, there was a very specific situation where it was possible to make an IP address personal data. But if you're not going to link that to a user account, and if you don't have any specific reasons to tie it to someone, well, it still is not personal data. And so that Breyer judgment was really very important from that perspective, but it was very rapidly interpreted in the wrong way to basically say IP addresses are personal data, full stop. That then had also an influence later on, because around the same time, the GDPR was finalized. And the GDPR, was adopted in 2016, and the application of the rule started in 2018. And so then there's one specific reference in the recitals to the GDPR, the kind of preparatory explanation, that says IP addresses and cookies and other identifiers can be personal data. Can. Well, I think, may be combined, etc. And so, again, it's that potential personal data aspect that is in there. It's not that they're always, but that they are potentially personal data. And so today, basically, we're still dealing with that. We're still dealing with this same idea that IP addresses could be personal data, but you do have to have additional information at your disposal. So did we go from something where it wasn't clear at all to something where it's very clear that it's all the time? No. It's just that basically we've clarified the fact that you need to have that additional information. What's been interesting is at the same time, you've had that evolution regarding consent, because this is the point, what were the rules like before? Are they now a bit stricter? And we've seen that since 2018, there's been more and more of an emphasis of regulators on the conditions for consent in the EU. And they've been clarifying them and sometimes even going beyond the text of the GDPR.
Yeah. And so how a lot of this has manifested itself within the greater ad tech space is that, like, if you ask anybody in ad tech about privacy and data protection, their first words out of their mouth is like, well, we don't touch PII. We don't touch PII. And as if that's a get out of jail free, type of a card. And it's really fascinating to me that on some level, we're almost 20 years into this and we're still dealing with the fundamental question about what is personal data and where is a consent required? Because if you talk to most EU regulators, everything is personal data and a consent is always required. Okay, so my number one recollection as an American lawyer was that there was always seemed to be some seemingly random data protection authority somewhere in Europe who would make proclamations about cookies being illegal. And then that would cause all kinds of waves in the business community here. And so what is it about the EU that seemingly allows so many cooks in the kitchen? And has GDPR really solved that problem?
The GDPR has not solved that problem. I can already tell you. And that is because of the fact that we have two systems to deal with. On the one hand, on cookies, we're talking about the e-privacy rules. E-privacy, I'm British, so privacy. But the e-privacy rules basically are the ones that deal with this cookie rule. And that basically say that for the storage of information on a device or the accessing or gaining of access to information already stored on the device, you need consent unless something is strictly necessary for the service or for transmission of a communication. So that's basically e-privacy. On the other hand, you have the GDPR. And the e-privacy rules are national. So every national regulator has its own remit. And the national rules sometimes change. There are some countries that have exceptions for analytics. There are like France, like Italy, like Spain, like the Netherlands. And then you've got others that just don't. So that already creates a bit of fragmentation. But then on the GDPR side, where normally we're supposed to have a kind of more uniform approach, even then you see that there are divergences between the approaches of different authorities. And it's a bit odd because you'd hope that we'd have a bit more harmonization, that we'd have a clear approach that is pan-EU, but it's not yet there, simply because the priorities of authorities are different. And sometimes, they have different perspectives. Like recently, there was a whole case regarding the Dutch authority that basically said you can't have legitimate interests when it comes to commercial interests. Commercial interests are not legitimate interests. And everyone else was saying, no, that can't be true. But you did then have these examples of national divergences, and there's no central authority, central regulator to basically say, no, this is the way we do it, and we're imposing a view on everyone else. Instead, there's a collaborative system where different authorities communicate, discuss together, and come up with a consensus. But then you still have certain divergences and you have certain disagreements among authorities also regarding the scope of those positions. So we don't have that kind of unified approach yet. I think the GDPR has helped to lead to a bit more often a unified approach, but we're still not there. And we're seeing that in the way that enforcement is happening. Just think about recently, regarding DeepSeek, there's been a fantastic flurry of actions from different authorities, with Italy saying, we're banning it from Italy, Ireland then asking questions, different authorities asking questions. It's not like there's everyone together. We're together figuring out what our position is. You see that fragmentation, and that's not great when you're in international business because you're basically facing so many different regulators. If you don't have an actual establishment in the EU, it's pretty difficult because you're dealing with lots of different regulators.
Yeah, and I don't mean to be overly critical of the EU or the EU process, and I will simply point out that we over here in the good old US of A have our own brand of what I'll call dysfunction. Number one, our definition of personal information is so broad that I actually don't know where personal information leaves off and de-identified data takes over. And we have a little bit of a Schrodinger's cat thing there where a data set can be both personal information and de-identified data. But also, we are rapidly approaching a scenario where we have multiple states each weighing in on their pet, privacy issues, and some of them are going to start taking slightly different positions, and that's going to be a world of fun for the business community. But anyway, okay, so it's now 2015, and we're heading towards the GDPR, and it's becoming pretty clear that a consent is going to be required in Europe for the serving of a digital ad, for whether it's legal basis or placement of a cookie. But what were some of the biggest challenges to the creation of the TCF? I know you have some insights there.
Yeah. No, so the TCF, basically, if you think about the story of it, the TCF came as a result of an observation that there was a need for a standardized approach to transparency on the one hand, and to documenting the legal grounds on the basis of which certain processing activities take place. So this is all in the case where we're processing personal data. And so, to your point of earlier about, are we processing personal data? The excuse was we're not using personally identifiable information. There's a similar reflex to be had by lots of actors today, still today. Am I really processing personal data? But if you assume that you are, then you have a number of key obligations under data protection laws in Europe. And the two main ones where there was a real need for a harmonized approach, a standardized approach, that was regarding transparency. So what do I tell people about what I'm doing with data? And then how do I communicate about the legal ground that I'm relying on? Now, everyone was already doing these processing activities. So the TCF isn't there to create those processing activities, as some have claimed, notably in the context of litigation. But they're there to help have a standardized approach so that there's a same way to explain the fact that I am going to be processing personal data, and this is what it's going to look like. This is what I'm going to do with it. These are the identities of those who are involved in that processing activity. And so there's a lot there that had to do with two key issues. And the first challenge then was coming up with a standardized approach and figuring out, what would be the scope of that. And through my contacts with people who've been involved in that from the very beginning, there have been lots of discussions about how do we label things. And so the biggest challenge, first, obviously, was getting people to want to do this. But secondly, it was figuring out how do we communicate in a common way? Because ultimately, this is about finding a common terminology, finding a common language, so we can all speak in the same way, that we can tell data subjects, internet users in particular in this context, what's happening? How are we going to use your data? Each of us individually, but we want to use the same language. And so because we have different approaches to personal data processing, and so different kinds of specific purposes, there was a lot of work to be done in terms of harmonizing the labels. How do I explain these? And so a lot of the background, the work in the back end was really about coming together as an industry and saying, we can agree on wording, we can agree on explanations. Then the kind of those next stage in terms of big challenges was explaining that to the broader public, obviously. And so the adoption process doesn't seem to have been always that easy, but then gradually you have more and more people coming on board, and then it grows very rapidly. And then nowadays, basically the TCF is the framework that is being implemented by, from what I heard, over 95% of commercial websites in the EU. So it shows that this has really grown. And then now you even have the TCF in Canada, you have other initiatives that basically have been derived from the TCF itself. And so it's a fantastic standardization project for the industry. But then now, after that kind of initial phase of challenges, the following phases of challenges all had to do with the enforcement aspect, where people start to say, well, is that really enabling compliance? I have questions about it. Who do I turn to? Who do I blame? And so that leads to a lot of litigation that is interesting in and of itself. But, it shows the fact that when you're trying to come together as an industry, you have to anticipate the fact that there will potentially be challenges. People will question, why are you doing that? And are you really doing it in the best possible way?
So it's funny, Ed, to hear you describe it, it just sounds all so wonderfully civilized. And so, I say that with a little bit of a smirk, because what I remember, both from the run up to the TCF and then a few years prior to that, as we started placing icons on ads here in the States, part of that self-regulatory movement, is these things become a bare knuckle fisted brawl really, really quickly. And boy, by the way, mad props to Julia Schulman and Matthias and the entire Townie and the entire team at the IAB-EU, because this was not an easy undertaking, trying to get all of these, just crazy cats herded. I'm going to make a bold statement here, and I want to get you to react to it. So in my view, the TCF works best as a way to get consent for the placement of cookies and as a general transparency tool. But once you go down the path of also getting a consent for profiling and ad targeting, I think the TCF runs into trouble. Do you agree, disagree?
I disagree. And that's actually because it's not so much about the TCF, but it's more about the activity itself. And this is where you see that the TCF itself, I'm a big fan of it, not just because now I've been contributing to certain groups in there and really seeing it evolve over the past couple of years in particular, but also simply because if you think about it, it's really a way of trying to get together as an industry and figuring out how do we get to better transparency, to better communication about what we're doing. And the TCF covers a whole range of purposes, and only some of them have to do with personalized ads, profile-based advertising. Basically, two purposes really are focused on that. And what you see them is the combination of those purposes and the actual underlying processing activity, which often uses OpenRTB notably to function, is that there's then this issue of complaints coming in, people feeling like, they're being watched all the time. And this is actually where the issues come. It's not from the TCF itself. It's from a perception of what profile-based advertising does and how it works. Because ultimately, if you think about how it works, the TCF, this is all about, saying this is a set of principles to say that when I'm going to be doing this processing activity, I'm actually going to declare it in a specific way. I'm going to talk about it. I'm going to be transparent about the fact that I'm doing this. So the issues that the TCF runs into are actually not TCF related. They're because the underlying processing activity raises certain eyebrows. Should it raise eyebrows? Should it require consent? I still like to challenge that, because I still like to think that, if you think about the way that the internet, the open web works, a lot of it is basically because businesses have found that certain kinds of advertising help them to build the business case. So then we could get into a whole debate about, contextual versus profile-based. And this is a kind of debate that is really interesting. Nowadays, we're starting to see more studies, empirical evidence going in one way or another. But ultimately, does it require consent? I still think you could argue that no. But it's really that combination that raises the issue. And this is where I think the trouble comes. It's because there's this particular approach regarding profile-based advertising that leads to complaints, that leads to enforcement, and that's where the trouble starts.
So I actually think we're in more agreement than I thought going in here. So my issue is not with the TCF per se. My issue is that if you're going to say you're getting a consent for the placement of cookie and you're going to get a consent for profiling and targeted advertising, that by my count is 2 consents. And the European Union does not like bundling consents. And so on some level, by buying into the notion that you absolutely need an additional consent for profiling and targeted ads, they've sort of set the whole mechanism up to fail a little bit with EU regulators.
But this is an interesting point, because when you think about that bundling, you're looking at it from the perspective of, well, cookies on the one hand and profile-based advertising on the other. But when you look at why you need that consent, if you say consent is needed for profile-based advertising, that's then based on the GDPR. It's based on the idea that this is personal data that is being processed for specific purposes. The cookie aspect is under the e-privacy rules. So nothing prevents you from combining consent to cookies for profile-based advertising. It's because we basically often have a 2-step approach, because we start with consent to cookies for a number of processing activities. And then within there, you then look at, okay, well, what is my consent for the processing of personal data? But you can actually combine them in a workable way. This is why I think that if you think about the way the TCF is implemented, there are some who really implement it in various stages, and this is potentially where the issue arises. Because if you look at the policies themselves of the TCF, you have that possibility to combine the certain ways of doing things together in a feature and so on. So there are ways to combine those.
Got it. And I think that's where that I'm not even sure there's a point of disagreement as between you and I, but the question is really, can one bundle a consent obtained under the e-privacy directive with a consent obtained via the GDPR? And we may have to leave that debate for a separate podcast, because I want to jump into get into paywalls and cookie walls. So, the GDPR has a very high bar for consent, specific, informed, freely given. And some websites sort of had some challenges meeting that standard. And so in order to push users into consent, sites have set up these cookie walls. And so walk the audience through here. What do I mean by a cookie wall? And what was the concern with the cookie wall under EU data protection law?
The cookie wall came really as a way of forcing people to make a choice. But initially, the cookie walls that we've seen have all been, about accept all cookies or go away. If you don't accept cookies in general, then we don't want you on our website. And that is problematic. And this is something that regulators have been fairly consistent about. If you're going to use a cookie wall, then you have to make sure that the thing you're blocking, if you're blocking access to something, that actually you are blocking access only because someone hasn't given consent or agreed to something that is actually needed for the website to function. Now, because we have behind us about 20, 30 years of people not really thinking about what is necessary to the functioning of a website, or not documenting, not arguing properly, then basically it's allowed a certain vision to take over, that basically everything that is not strictly speaking functional is not necessary for the functioning of a website.
That sort of puts EU regulators in a weird position, because there's no such thing as a business that I could walk into and say, hey, you know what, Starbucks, I don't want to pay for this coffee, but I think you should give it to me anyway.
Of course.
And it sort of puts EU regulators in a weird spot, because it's very debatable what is and what isn't really necessary for a website to function.
Agreed. And this is where I think that now we're getting to a point of a bit more maturity in the discussion. We're finally getting a debate. Notably because some random people like me say, we maybe should not always think of it that way. And it's because, you get more and more people saying, well, there's the freedom to conduct a business. That is also relevant. You do have the possibility to run your business. There's no obligation to make anything available for free, full stop. And so I choose the conditions, to use the example of Starbucks. When I walk into a Starbucks sets the conditions under which I'm able to benefit from the service. Some of those I might find personally to be exorbitant. I might find that a coffee for, I'm exaggerating here, but for $25, I would never pay for that. But maybe my neighbor will. And so then you get into an interesting debate about who sets the tone, who decides what is necessary. Is it the business? Is it every individual customer separately? Is it a regulator? What about the case where someone might be in a more difficult position financially, or if someone might have a disability? Does that mean that they are prevented from enjoying the service in the same way if the condition excludes them? So you get a whole range of, as such, really fascinating questions from a legal perspective, but they don't help businesses because that uncertainty blocks them. So the cookie walls really kind of were a way of cutting short that discussion, saying, we don't want to get into that. You accept or you leave. But once regulators started to push against that, then you got an evolution of how do we do this? And that led more to the paywall approach, where we're not saying, just accept all cookies or leave this website, but suddenly we're getting more into a more nuanced definition of what is the service, and then kind of different tiers of a service. And then you have the kind of low version, where you probably might get access to a website, but you might see more ads. And then you have the paid version, where either you see no ads or you see fewer ads. And then this is when you get into that kind of tiered approach to access to the content.
There's other places where micropayments are a much, much larger, percentage of the equation here. In the West, we tend to like ad supported because people have sort of been trained on everything is free and that's wonderful. And then there's certainly an underbelly to that. The reality is that, publishers need to keep the lights on and they need to figure out how to monetize their content in some way. And one of the challenges is that you've got big tech sitting on a very large chunk of their ad revenue, and in a mobile context, I suppose, and the subscription revenue as well. Okay. So I wanted to talk a little bit about what, Meta has sort of become the lightning rod for everything data protection in the ad space in Europe anyway. And they had sort of a famous case that went down, a year and a half. It's been playing out for a number of years because first, the EU said, well, you can't use contractual necessity. You can't use legitimate interest. Okay, well, we'll use consent. Problem with consent, I think in general, is that as a large entity, there's an unequal bargaining position as between Meta and your typical user on the street. But walk me through that, that history a little bit. Like, what's going on there?
So the idea behind these evolutions is that when confronted with the idea, I want to make available my service. I want to make my service available to EU users, but it's going to be ad funded. Well, initially there was that idea, this is logical. It's part of the contract, that when I enter into a contract with Meta to use my Facebook account, then basically I agree to terms of service. And those terms of service include the fact that there is some kind of consideration. And when we're in that logic of free services that I'm not paying for directly, there's always that counterpart. Well, someone else is paying for it. And that someone else is basically through ad revenue in this context. Because, they're not a public or a utility. They don't get funds from the government, which basically would be funds coming from me anyway. So I would not be paying indirectly as a taxpayer. I'm not paying directly as with my wallet, well, then there's somehow else that basically they're being compensated for the fact that they're offering this service. So that idea was, it's baked into the contract, it's part of it. It's logical that it's all together. It's the consideration for the fact that I'm benefiting from that service. And there, the idea that was given, the reasoning that was given at the level of the EU Court of Justice was where you can't rely on contract as a legal ground for this processing activity of basically profile-based advertising, because we don't see this as being part of the definition of a social media service. That the social media service, based on these factual considerations by the Court of Justice, I'll get back to that in a second, but these factual considerations led them to say, the service itself is not in return for profile-based advertising, that personalization of the advertising itself, that this was not part of the definition of the service. Now, I say, factual considerations. The interesting thing in this story is that the Court of Justice is supposed to only really deal with the legal issues, the points of law. How do I interpret the law? And so they have a couple of factual considerations in this judgment of July 2023 in the meantime, but basically they have these factual positions, and I don't really agree with all of them. And I think that the part of the issue is they've taken a certain factual position, and so now how do you disagree with that? How do you question that? When in fact it wasn't really their place to say that. So contract excluded from their perspective because they define the social media service in a particular way. How about legitimate interests, which is kind of a fallback provision, but it's not a fallback in the sense that you can use it in every single situation. You also have to document your justification for using it. And there, the position of the Court of Justice was, well, you can't rely on that because the interests, the rights and freedoms of the individual, of the natural person, the data subject, prevail over the interest of Meta in this context to basically serve profile-based advertising. Again, based on certain factual considerations that could be questioned by a national court, but it led to that idea, well, actually, none of those two legal grounds is available. So that leaves basically only one in practice, because the other three legal grounds are not used by private entities in these contexts. So there's legitimate interest, contract, or consent in practice for private entities. And then you're faced with this idea, well, you need to have a freely given, specific, informed, and unambiguous consent. How do you do that? Because the freely given aspect is the one that raises the biggest issue here. If I want to get to benefit from a service, but I have to give consent to profile-based advertising in order to benefit from the service because it's a consideration for it, is it really freely given? And there's a really specific provision in the GDPR that I think is underutilized and underappreciated, but that basically allows you to combine a contract and consent. Article 7.4 GDPR is really specific, but basically it's one that allows you to say that consent is freely given if you can show that the processing is necessary for the contract. But so this is one that hasn't been explored sufficiently by the Court of Justice, I think. But then basically you end up with that situation where you need to give consent to profile-based advertising because the Court of Justice seems to suggest that's the only way. And then you do have that issue of, is it really freely given if it's bundled as part of the service? And that's led to that whole idea, well, how do we disassociate profile-based advertising from the service itself? So you had the GDPR on the one hand, and then on the other hand, you had external pressure through other laws, notably the Digital Markets Act. But basically, from a GDPR perspective, that led to that question, well, how can Meta offer a service that allows for freely given consent? And that's when they turn to the idea of the pay or okay approach, the subscribe or add. Because if you then use that, if you use this approach, actually you do have freedom. I, as a user, have the freedom to give my consent to profile-based advertising, or part of my freedom is the other option that I pay with my wallet. So I have that choice. Now, there might be cases where, from a financial perspective, I don't want to make that choice. I don't feel like I have really two options in practice because maybe I have less income. Maybe I've already subscribed to other things like Netflix and Spotify, and maybe I don't have enough that I think I want to dedicate to digital services. All right. But you also always make a choice with every other service, whether it's digital or physical. You can choose to go get your coffee at Starbucks, or you could go, you fetch it at the local cafe. And one of them might be pricier than the other. There are alternatives. Then that led to the discussion in the context of the regulator's assessment of the subscriber as the pay or okay approach of Facebook and Instagram. Well, there are no alternatives. There's a strong presence on the market and so on. And that led to an opinion of the European Data Protection Board that said, you, Meta, cannot require consent. They basically didn't say Meta, but in practice, it was for Meta and a number of other undefined large online platforms, whatever that means. But they basically said you can't require consent in these cases because you're too important. A very fun thing, I think, because coming from the regulators, a lot of them have constantly said, I'm not on Facebook, I'm not on Instagram. So they showed that we could live without them. But it's interesting because it shows that there's a disregard for the possibility of moving to an alternative, whether it's consciously that they're kind of avoiding that discussion or not. I think it's an interesting given part of the conversation.
I'm not going to be here arguing the position of any particular EU data protection regulator, but I can understand the idea that all the social platforms, really all of big tech, have just been allowed to grow so large and are just such a big part of our current society that there is something to the idea that not being on one of them. All right. So, for example, LinkedIn. What would it do to our careers if we didn't feel comfortable, broadcasting all of our wonderful thoughts and opinions on LinkedIn as a way to, increase our visibility in the industry? Like, that would be hard to get rid of. And you and I, relative to others, have a lot more power.
And this is the interesting thing, because when you start to think about it, the first reflex is I can't live without it. I have been building my presence on LinkedIn through publications, these in-depth assessments and so on for years now. And so there's a lot of investment in the back end. That means that for me, it would be potentially more difficult to switch to something else. But nothing prevents me from then gradually going somewhere else as well. And so you have a number of people who have over the years been cultivating a presence on multiple social media platforms. And then, for instance, there have been several calls to quit Facebook, to quit Twitter, or now X, to quit LinkedIn. There's always been something about this. So there's the question that this raises is, do I then have to look at the subjective assessment of one particular person? And that is where things get really difficult, because if we have to take into account the position of every individual, how can a business actually move ahead with any decision? How can a regulator take a common view about what is relevant? Because if we take the position of Alan and Peter, yes, LinkedIn is difficult for us to quit, but is that a relevant measure? And this is where you get into interesting discussions about how do you assess that?
No, and I feel like we've now started to gravitate into the we should open up a bottle of wine portion of the discussion here. But because I agree with you. If you're going to take a principled stand in life, there are sometimes costs to that principled stand. And that's just a reality. And so the idea that EU data protection law is going to remove the cost of taking principled stands, to me on its face seems a little absurd. But this has been a fantastic discussion. Before I let you go, I wanted to, we ask a lot of our guests, what is your hobby or passion? And I'd love to hear yours, Peter.
Well, I've got a hobby that is not too far removed from your not complete hobby, your semi-professional one, because I've been composing music for, 20 odd years. And every now and again, I sit behind my piano keyboard and I start doing stuff. And I actually recently composed a Christmas song, but it's not at all ready for, it's not been recorded, but it's, there are things like that I do every now and again. And it's fun because it's the kind of novelty act idea that you can have. If I go to a family event, I can always find a piano somewhere. There's bound to be something that you can do somewhere in the airport lounge or at an event or somewhere, and then you can just randomly start playing something that you've composed or just make it up as you go along. And so one thing I like to do then is if there's a piano and there are people singing, well, then I just randomly start accompanying them or figure out what it sounds like as we go on.
Well, I hope at the next IAPP, Trevor Hughes, if you're listening, and I know he is, bring a baby grand into the next reception at the IAPP event in Washington, D.C. Maybe even bring two. Peter and I will have a piano off.
Yeah.
Peter, thank you so much. This has been a fantastic discussion. I really appreciate you coming on.
Thanks, Adam. It's been great.
That was a really fun conversation. We've got a bunch of other fantastic guests coming up on the Monopoly Report podcast over the next few weeks. Please subscribe to the show at monopolyreportpod.com or on Spotify, Apple, YouTube, or wherever you listen to your podcasts. Peter, thanks so much for coming on.
Thank you for listening to the Marketecture Podcast. New episodes come out every Friday, and an insightful vendor interview is published each Monday. You can subscribe to our library of hundreds of executive interviews at marketecture.tv. You can also sign up for free for our weekly newsletter with my original strategic insights on the week's news at news.marketecture.tv. And if you're feeling social, we operate a vibrant Slack community that you can apply to join at adtechgod.com.